Hi there, Brian Qualls, estate planning attorney, and I'm here to help you understand what a trust is, otherwise known as a living trust or a revocable trust. This short video is going to make it crystal clear so that you finally understand what a trust is all about. Technically, a trust is a revocable document. It's an agreement that creates a new relationship with a person and their property or their assets. So it is a revocable document that is going to simply change the way that someone owns their assets. You still own everything. You're just going to own it in a different and better way that's going to effectively accomplish all of your most important estate and legacy planning goals. To make it easier to understand, think of your trust as being like a bucket, because we can all see a bucket in our mind's eye. So imagine that you're holding a bucket, or if you're married, you and your spouse are holding a bucket together, and you're putting your most significant assets inside of your bucket. So you're putting your real estate holdings inside of your bucket, your home or any other properties. You're putting your investments, stocks, bonds, securities in your bucket, bank accounts, life insurance, death benefits. All of these important assets are going to be in some way integrated with this bucket. The important things to know about this bucket is, first, while you're alive and well, you get to hold your own bucket. So you're in complete control. You can remove assets from the bucket. You can sell property if you want. You can give something away if you want to. You can add additional assets into the bucket. If you buy a new property, you can put that in the bucket. Anything that you want to do, just like you can today, you're able to do when you have a bucket. Nothing changes. What does change in a very positive way is what happens if you're not able to hold your own bucket anymore due to either incapacity, which could be mental or physical, or because we've kicked the bucket and we've died. If either of those instances occur, the bucket is able to be handed over to the person that we trust. We call that person a successor trustee. And the successor trustee is legally responsible for administering our bucket for the benefit of who is supposed to get it next, meaning it can legally transfer ownership of the bucket to whoever is supposed to have it after you. Or if you're still living, use the assets in the bucket for your support, and at which time that you pass away, ownership and beneficial enjoyment of all of those assets is going to be transferred to the successor beneficiaries, such as a spouse or such as your children, if you have them. The most important thing about the trust that comes up in pretty much every consultation that I have is that it avoids probate. The trust avoids court involvement with your assets that would otherwise be necessary if you didn't have a trust and you had any significant assets, which would mean any real estate or any combination of other assets over a certain threshold, which is about $180,000. If a person doesn't have any real estate or they don't have any other assets that combined total to somewhere around $180,000, they may not need a trust because probate wouldn't be necessary to transfer those assets at their death. But if we do have any real estate or other assets combined over that threshold, and then we die, to get those assets out of our name, it's going to require a court process called probate, which takes about 1.5 years to complete, and it winds up costing about 5% of the gross market value of everything that a person owned that's passing through probate, changing ownership through that court process. So it is not ideal, it's very time consuming, it's very expensive, it's very stressful, and it's also public. All of the personal financial details of the person that died are going to be available in court records that are viewable by the general public, which creates a real privacy concern. Additionally, probate is also going to state, as part of that documentation that is part of the public record, who is going to be inheriting that person's assets, which creates a different kind of concern, because now we've got potential predators who are now going to be aware of who's going to be inheriting what and when. Probate is not a place where we want to be, and the living trust is the ultimate solution to avoiding probate. There are 3 parties in a trust relationship. You will be all 3 of these things during your lifetime. You will always be the settlor, otherwise known as the grantor or the trustor. That means that you're the person or the people that created the trust relationship in the first place. That will always be you. You will also be the trustee or the purse strings holder. You're in complete control. You decide what happens. When you can't be the trustee anymore due to incapacity or death, the people that you trust, a successor trustee, which if you're married will likely be your spouse, continuing to be the trustee. And when they can't, then the other individuals that you've named, which can always be changed, are able to legally immediately step in and take over the trust for the benefit of the next beneficiaries, which is our last party in the trust, is the beneficiary. That is going to be you during your lifetime. You're the person entitled to the benefit, use, and enjoyment of all of your assets, just like you are today. When you pass away, the people that you have named as the next beneficiaries will immediately become vested beneficiaries entitled to your assets in the way that you want them to receive. So I hope that that was a helpful overview for you, and I congratulate you on taking the time to get educated on this topic, and I look forward to continuing this journey with you.